Okay.
Here we go.
Oh, we transfer. Okay. Yeah, what's the date? It's July 8th.
July 8th.
Yeah. Okay, good. We didn't have. Jan.
You see Maria.
I told her.
Okay.
She'll be on her way down. Yeah.
All right. First meeting in District Court, County of Washington, State of Michigan is now in session. All those having business before the court draw near, the Honorable Judge J. Cedric Simpson preside.
You may be seated. That's that'll work. Camera's reversed. It's taking that picture, not this one, but I'll switch. All right. Miss Linda. But I don't have a PD to do it. Well, hold on a second. Whose case is this? Oh, then I don't need the waiver at this point. We'll just have to make sure.
The prosecutor, Ms. Thomas, not here. All it's gonna be is.
Who?
Circuit court. I'm looking for.
What, nobody's ready? Is that me?
Oh, we're ready, Judge. Just give me a second.
We're ready and now you're leaving.
I'm looking for.
So that was a no, they weren't ready. Somehow. Ready now?
Good morning, Judge.
Good morning.
I apologize. Sir.
No, it's okay.
Fire.
What'd you say?
So I apologize. I was putting out a fire.
That's all right. That's all right. Court does call the case. People, State of Michigan versus Justine Cheatham.
Good morning, Your Honor. Marie Campbell, Assistant District Attorney on behalf of people.
Good morning, Rob Jekyll on behalf of Destiny Cheatham, who's on Zoom, and we appreciate allowing her to be on Zoom. Destiny, would you state your name for the record, please?
Destiny Cheatham.
Okay,
Do you have a
so-
camera, Destiny?
No, I don't. My screen is shattered.
Okay, I know her voice, Judge. That's her. What we'd like to do
Or
today.
either you're gonna waive.
Yes, Judge.
Does
We're
either
waiving-
party have an objection to her not having a camera?
No.
I'm
Do you,
sorry.
do you object to her not having a camera?
No, you're-
All right, very good. All right, it's gonna be a waiver. Ms.
Yes.
Cheatham,
Yes.
you understand that you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand you'll not have that hearing today and you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yeah.
Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Judge, we acknowledge the information waive its reading. My client would stand mute.
Defendant having waived formal reading, standing mute, court will enter not guilty. The pretrial will be set for July 8, 2025, 1:30, Judge Conkey.
Thanks, Judge. Judge, we do appreciate allowing my client to appear by Zoom. Thank you.
No problem. Yes, just one moment. Bond will continue in this matter.
Thank you, Your Honor.
Sir, we don't have an information.
I can look and pull for this, yeah.
Yeah, we'll get an information for you.
Okay, thank you.
Got it.
Call for Mr. Oldham.
It's a PD case.
No.
This flap isn't gonna work. Well, the camera, I gotta flip the camera. I just haven't. And I gotta remember how to do it. Anne was supposed to have this all set, but she didn't. What? By the time you show up.
Yeah, need to put a waiver on there.
We were trying to do that hours. But, okay, well, hold on 1 moment. I'm gonna take care of Mr. Bird. Court does call the case People versus Sean Odom.
Alexander, on behalf of the people, Your Honor.
Good morning, Your Honor. Morning to your honorable staff. If it please this court, Brandon Bird, PA 3734, on behalf of Sean Odom. Mr. Odom, can you please state your full name for the record?
Sean Martell Odom.
Thank you.
You welcome.
Today's the date and time set for preliminary examination. At this time, the people are unable to proceed as to count 1, and whereas that count 2 and the added count 3 on the amended complaint be remanded to district court.
All right, as to the amended count 3, the domestic violence second offense, you waive formal reading of that charge, counsel, and your client pleads not guilty.
Yes, Your Honor.
All right,
Respectfully.
you need a copy of it?
Right, I never seen the amended complaint, Your Honor. Let's see.
Today?
Yeah.
Oh, no, I'm kidding. Charge? Patience is my #1 virtue.
Let's see.
Did you want me to pass it so you can go over that with your client?
Yeah, let me please.
Okay.
Your Honor.
So I'll pass the matter. We'll take him back, then you can go run and talk to your client. Call it back up. And then why don't we put the waiver on the record if we could?
Good morning, Your Honor. Alexander, on behalf of the people, Your Honor, the people would waive any potential conflict between this honorable court and the office of the public defender. While the people don't believe this conflict exists, people make this waiver in avoidance of any doubt.
Your Honor, Lauren Brown, Deputy Chief Public Defender, our office would likewise waive any potential conflicts. We do not believe such conflicts exist in this honorable court hearing these matters. If a conflict were to arise, we'd waive such conflicts so that this honorable court could hear these matters.
And the court for its part also does not believe there's conflict either in Michigan court rules or the cases decided they're under. To the extent a conflict does exist, given the waivers, the court will consent to either of those matters. We have nothing. Really? So no, we have nothing. I depend on you to keep us going.
Waiting to hear back on.
So it's the other people that are causing the problem. Okay, just threw them right under the bus. What's Warren Green doing? Are you ready?
Very, very.
But you have.
So smooth.
Okay. Mr. Brown, you're looking very dapper, but you don't have anything ready either? It is. It really is. It really is.
Thank you very much. Thank you.
Yeah. Very fashionable.
I'm not used to all this compliments.
Oh, don't worry. It's gonna last about 5 minutes and then we're back to normal. Miss Maggie, how are you?
I'm good. How are you?
I'm doing well. Wonderful.
So,
Okay, so finally, she's arrived, so things will get going.
Well, we have someone.
Miss Willingbrings like, what? All right, we're gonna turn this camera. Well. And I think they did it there. Well, here's the problem. Yeah, something's gonna have to be done, but. Okay. Is it? What motion? Oh, it's got that thing. Okay. We'll. Oh, cutting it. It's. No, I know. Let's not say we did.
So this is just what we would have added anyway.
Oh, I see. So you have to.
Uh-oh. Were you all set or you?
Ready, yeah.
Okay. You're all set because Mr. Johnson just walked in, so that's trouble. I'm just saying, so everybody better get their things out of the way before he starts. All right, we're gonna bring him back. Don't talk to Warren Green. Court has recalled the case. People versus Sean Odom.
Alexander, on behalf of the people, Your Honor.
Yes, Your Honor. Brandon Byrd on behalf of Sean Odom. Mr. Odom, can you state your name for the record again?
Sean Martell Autumn.
Thank you.
You're welcome.
All right.
Yes, Your Honor. We did get a chance to discuss this with my client. Understandable. We're gonna wait a formal reading, stand mute.
All right. Court will enter not guilty plea as to that count 3. Maintain his plea of not guilty as to count 2. Count 1 will be dismissed. I'll set a pretrial on counts 2 and 3 for May 28, 2025, 9 a.m. That is before Judge Perry at the 15th District Court on the misdemeanor charges. All right.
Permission to address bond, Your Honor.
Figured you would. Go ahead.
Respectfully, we got the misdemeanor that was dropped today. It's the same complaining witness that's on this case. That's just been dropped to the second. So I'm not sure, really how far this case is gonna go, but that's something we'll see in district court. Essentially, my client has been in jail for, since March.
Yeah,
What do you-
about a month.
About a month.
Keeping-
Roughly about a month now. Now it's pushed back almost 2 weeks, Your Honor, for 2 misdemeanors, which essentially could potentially be probationable, or
You got,
it's almost like he'd be serving a sentence if he stays in jail too much longer. One of these is a 93-day misdemeanor. I understand the other one's up to a year. But respectfully, we're gonna ask for a personal bond in this matter. He understands no contact with the complaining witness. He doesn't want any contact with the complaining witness. My client doesn't want to be sitting in the jail cell like.
well,
is right now.
he had a personal and then messed that up.
Understandable, Your Honor, but now we're dealing with a whole new set of situations in which my client's been sitting in jail for a month now, almost a month. And I'm pretty sure a month in jail gives you a lot of time to think about where you want to be and where you don't want to be, and how you operate.
Answer the people. I wanna go back to work.
Severe concerns that he can follow court orders. He did pick up that bond violation where he was in contact with the victim while out on bond and had another assaultive incident with her. And in this case, he had an assaultive incident with her and her child, giving the child a black eye. I also concerned because he's currently on probation in 15 for leaving with this same victim. So I don't believe he can keep himself from being in contact with her, and I have great concerns for her safety and her child's, given the facts of this case and his previous history with numerous dismissed DVs and convictions on DV.
Anything else, Counsel?
Respectfully, Your Honor, my client went to the police station. He went to the police station and made a police report in Ann Arbor, Ann Arbor. That's one of the reasons for the contact.
So just, right, but here's what ended up happening. He had a personal bond. He didn't follow the conditions. He then came into custody, was arraigned, and the bond was set at where it is now. As a result of his failure to follow the conditions. And then that is even really outside of the other stuff that the prosecutors indicated regarding the other contacts and other complaints that he has with the victim in the case. What I'm going to do is I'm going to deny your request to reduce his bond. You can take it up with Judge Perry, but at this point, I'll do it that way.
Thank you for hearing me out, Your Honor.
Oh, I'm sorry. Court called case People versus Jalen Kendrick.
Ally Zend on behalf of the people, Your Honor.
Oh, boy. Oh, no.
Good morning, Your Honor. Student Attorney Kara Rosengren requesting to practice under Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Hannah Apple on behalf of Mr. Kendrick. Could you say your name?
Jalen Kendrick. So where are you from?
Me?
I know where he's from. I got all that information. I know where Apple's from. Yeah, you.
I attend Cooley Law School, Your Honor.
You do?
Yes.
Oh, a Michigander or you?
Yes.
What part?
I currently reside in Dexter, Your Honor.
So even a Washtenaw County, Michigan.
Yes, Your Honor.
Where are you originally from?
Oakland County, Holly, Michigan.
Yeah, kind of blew it there. Okay. Where'd you go to undergrad?
Western Michigan.
So you just never left the state?
I actually lived in Chicago for 15 years, Your Honor, so.
Did you?
Mhm.
Didn't like it?
Loved it, but came back for my husband's job.
Oh, he's to blame. All right. Permission to practice is granted. Welcome aboard.
Thank you.
And Your Honor, today's date and time set for preliminary examination. At this time, people are unable to proceed as to count one and would ask that count two be remanded to district court.
You're moving to dismiss count one.
Yes, Your Honor.
People being unable to proceed as to count one is dismissed. I'll maintain the defendant's not guilty plea as to count two. Pretrial in this matter will then be set for June 9th, 2025, 9 a.m. That is before Judge Washington. Thank you.
Thank you.
Bond will continue. Thank you. Court does call the case People versus Quinard Sanders.
Good morning, Your Honor. Alex Warren, Green on behalf of Mr. Sanders. State your name.
Bernard Sanders.
I have a plea form in front of me.
Correct, Your Honor. We are going to be proceeding on a guilty plea. Mr. Sanders is currently executing a sentencing judge waiver and the advice of rights form for the court.
All right. Plea form indicates that the defendant will be pleading guilty to an added count two of attempted resisting and obstructing a one-year offense. Upon a successful plea to that charge, count one would be dismissed. There's further the agreement of no delayed or deferred sentencing. That's the court's full understanding of the agreement.
That's our understanding, Your Honor.
Is that correct, counsel? All right, very good. May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth self you got? State your name.
Bernard Sanders.
All right, sir, it is this court's understanding that you are going to be pleading guilty to the charge of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. Do you understand that, sir?
Yes, sir.
You understand also that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Barr in the 1482 District Court. You understand that?
Yes, sir.
All right. Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
Nope.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Well,
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
no, Your Honor.
Sorry.
No.
Has anybody threatened you or forced?
No.
You're doing this voluntarily
Yes, Your Honor.
of your own free will?
Yes.
And because you believe that you're guilty of this offense?
Yes, Your Honor.
On the date of December 17, 2024, at the location 500 West Cross Street, City of Ypsilanti, Washtenaw County, State of Michigan, did you come into contact with a police officer from the Ypsilanti Police Department?
Yes, Your Honor.
What happened?
He asked me to get in the car and I ran.
I'm sorry?
He asked me to get in the car and I ran.
May I have what do, Your Honor?
Pardon?
Ma'am,
Yeah,
what-
go ahead.
Mr. Sanders, you were approached by a uniformed officer on that date at that location, right?
Yes.
And that officer informed you that he was investigating a crime, right?
Yeah.
And you began walking away, right?
Yep.
And he told you to stop.
Yep.
And you ran.
Yes.
Okay. You knew he was a police officer, right?
Yes.
Okay. You don't dispute that he was acting pursuant to his lawful duties, do you?
Nope.
All right. Your Honor, I believe that lays a factual basis.
As the court complied with the court rule, would it be proper to accept this defendant's plea?
Defense is satisfied.
Court will accept the defendant's plea to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 1482 probation. Sentencing will be
May 28th at 10 a.m.
May 28, 2025, 10 a.m. before Judge Barr.
Yeah.
Bond will continue.
Thank you, Your Honor.
All right, thank you. Thank you, Mr. Sanders. Court does call the case of People versus Stephen Watson. Pardon?
Mr. Watson.
They got him. Oh, we gotta wait.
We're ready in this matter, Your Honor.
Good morning, Your Honor. Katie Rismersky. People.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Stephen Watson. Mr. Watson, please state your name for the.
Stephen Watson.
All right. What are we doing?
Your Honor, as the court is aware, this time and place scheduled for preliminary examination, people are able to proceed this morning. I would anticipate a motion to dismiss the felony. I would be seeking a remand on misdemeanor, but I seek the court's guidance as well. It's charged as a DD first, and it should be a DD second. I apologize to the court of counsel that I do not have a DD complaint prepared, but I could move to add a count 3 of DD second or amend count 2, whatever the court's preference is.
Oh. Can we? Ms. Zenda is like an expert
I mean,
at getting those amended complaints done. And so I think Ms. Zenda might help you out
I
there.
think she's doing the things right now.
Oh, is she? Okay, see? So what I will do then is, and should we do that? I mean, it's my case, so I'll remember, but should we do that as count 3 or just amending count 2?
Just amend the
Count 2, you think will work? Okay. So we'll just amend count 2 to reflect into DV second.
Wonderful. Thank you.
And you're waiving reading on that,
Yes, Your Honor.
and I'll just indicate that we'll maintain his plea to the amended count 2 in this matter of DV second. Count 1 would be dismissed as people are unable to proceed. I'll set a pretrial in this matter for
May 19th at 1 p.m.
May 19th, 2025, 1 p.m. That's before me.
Thank you, Your Honor. May we address the issue of bond?
Sure.
Honor, my client was out. He had difficulty and I believe there were issues with
Positive drops.
positive testing.
Get back to work.
My client does have employment. He is hoping that the job is maintained for him, but he does not think it will be maintained for too much longer past today's date. The felony charge was dismissed because there is no complaining witness. I expect there will probably not be a complaining witness at the court date as well. Based on that, Your Honor, I'd ask that my client's bond be returned to its previous state. My client has indicated that he will follow all of the strictures of the court. He has learned the importance of not indulging in drug use during any time period. He's asking that he be allowed to have his bond reinstated. The time he has sat in has taught him a valuable lesson.
The problem is that he was testing positive. That's part of the problem. The other part of the problem is he was supposed to then start CCOP and he didn't appear.
I talked to the agent and working a lot of hours. Told me to come to court and signed up for the COP or whatever, because I can do intensive outpatient treatment.
So, Your Honor, he did have contact, but the problem was at the time he was working a lot of hours and he had gone past the time when he should have been reporting. He did speak to the agent. Agent told him to come to court and then he could start getting into the program then. It's not that he doesn't want to. It's not that he intentionally tried to avoid what needs to be done. He set priorities with working and maintaining himself and his family. And that priority, as it turns out, was the incorrect. He has learned then what the priority should be. And again, it's not like he didn't make contact at all. He did do that. He was working. We'd like to continue to maintain that employment.
Okay, I don't need a response from the people. I'm gonna, at this moment, deny your request. I'll look at it again come the 19th. Since it's coming back before me, it's just less than 6 days from now. I'll take a look at it. I would like to see something that's gonna keep him on track. Because if he continues to use, doesn't do anything, we're gonna be right back in the same boat. So
I'm not gonna use, my job is at risk and I'm with positive drops and I can guarantee that, I'm just trying to get back to work. My job is.
no, I hear you.
Yeah, just since
But-
I really learned my lesson, I understand like the importance of not dropping dirty and things like that. And I have learned my lesson. I don't need to be in here. If you give me a chance, I won't let you down. I really just trying to get back to work and
How many times do you think I hear that?
a lot, Your Honor, a lot. And I
So
guarantee,
tell me what makes you different.
because I got 6 kids, I got a lot of things going on and I'm not a person that constantly gets in trouble, I'm done with the drug use. My system is clean, so you have no problems with that. So if I drop today, drop next week before I come to court, everything could come back the same. And you got my word on that. Like,
So if I were to let you out, if I change my mind and I were to let you out, you test dirty or don't follow anything.
I would do the time in jail. But I'm
You're
not.
gonna do it right now anyway.
Yeah, but I'm not trying to do that. But what I'm saying is, I come back and plead guilty to everything. I'm just really trying to get back to work, and you won't have no problems out of me
I
after
think you
today.
need to get yourself set up with some type of outpatient.
Yeah, and that's what I'm saying. If I go to community corrections today, I can sign up for the intensive outpatient treatment, so I can be able to get on the right track. But there
I'll
will
tell
be
you what, I'm gonna at this moment deny your request. However, if council would contact community corrections, see what they need, I will consider an order to release him with some strict compliance in their program.
See if they have something in place for you. Okay.
Okay.
Oh, yeah.
Please.
So I'm not saying no forever, but I'm gonna need something that,
Thank you, Your Honor.
thank you.
So,
Thank you, Judge.
And after that,
You have to turn off center stage. Huh?
Sorry.
Just walk in, start throwing things down? What? I'm not, no, too easy. Not gonna say anything. Welcome back. All right. So what are we doing? This one? Got him? Okay. Court calls the case, People versus Timothy Stevens.
Alexander, on behalf of the people, Your Honor.
Oh, you're back.
Student Attorney Kara Rosengren, on behalf of Mr. Stevens, Your Honor. Say your name.
She's back.
Stevens.
Your name, sir?
Timothy Stevens.
Thank you.
In your understanding concept of preliminary examination, at this time, the people are unable to proceed as to counts 1 and 2, as that count 3 be remanded to district court.
So you're moving to dismiss counts 1 and 2?
Yes, Your Honor.
Counts 1 and 2 are dismissed. I'll maintain the defendant's not guilty plea as to count 3. Set a pretrial in this matter for
June 5th, before Judge Fresh Hour.
June 10th, you said? 5th, 2025, 10 a.m. I'm sorry. 10 a.m. before Judge Fresh Hour.
Thank you.
Yeah, on continue.
Thank you, Your Honor.
Thank you.
She's a lot nicer than you, Apple. I just thought I'd throw that out there. She didn't give me a lot of argument about stuff. Isn't that true? No? Why, man? It's supposed to, me and you. No, she's really not.
Over there.
She's okay. That's it? That's all we have ready? What are all these people doing here now?
Came to see you.
Is that what you just said? Okay. Well, I guess I'll take a break and wait for more to get ready and then come back. She's leaving? Does she have to go with Apple? I like her better.
Better?
Well, okay, better may be the inappropriate word. To dismissal, okay. Do this. Court does call the case, People versus Deborah Gilmore.
Katie Rosmerski for the people.
Yes, Your Honor, Brandon Byrd on behalf of Deborah Gilmore. Ms. Gilmore, can you please state your full name for the record?
Deborah Gilmore.
Morning, Your Honor. People are unable to proceed at this point.
All right.
Respectfully request dismissal, Your Honor.
Your Honor, request a remand for this meeting.
All right. People being unable to proceed as to count one, that is dismissed. I'll maintain the not guilty plea as to count two. I'll set that for a pretrial on
June 9th at 9 a.m. for the Washington.
June 9th, 2025, 9 a.m.
Yes.
9 a.m. before Judge Wash.
Thank you, Judge.
Thank you, Bond.
Right.
Go continue. Thank you. Take care. That's it. Okay, then I'll stand in recess and you'll let me know when we're ready on other things. So court's in recess.
All right.
Yeah.
You know, just-
You can be seated. And Did that do it? Okay.
And now you're gonna-
No. Not touch anything. Okay. Well, we got new equipment and didn't know how to work it, so. Court does call the case, people versus Brandon G.
And is it on behalf of the people, Your Honor?
Assistant Public Defender Ben Dunaway on behalf of Mr. Gevers, who is standing to my right. Brandon, would you state your name for the record, please?
Brandon Gevers.
Your Honor. Yes, Your Honor.
So you're waiving your right to a preliminary examination?
Yes, sir.
You understand that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand that you'll not have that here. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on count 1 with 2 following.
Your Honor, we will waive the formal reading and stand mute.
Defendant having waived formal reading, standing mute, both counts. Court will enter a not guilty plea. Pretrial will be set for July 17, 2025, 1:30, Judge Slay.
Your Honor, could I address Braun briefly?
He's out.
He's out, but he's on a tether, and the complaining witness apparently lives thousands of miles away. So I don't think the tether serves any purpose, and we'd ask the court to take it off.
Your Honor, I just have concerns given the facts of this case. I'll leave it in the court's discretion, but I just have concerns given the highly valued factors in this case of strangulation. But she does reside out of state, Your Honor.
They're not in any proximity to each other.
No.
At all. It's just a GPS location track.
I would ask the court, if we don't leave the tether on until tomorrow, she is in state today. So I would have concerns for her safety while she's here, and ask if the tether be moved tomorrow when she's back out of state.
Right. His bond will continue. What I will do is I send an order. We'll remove the GPS tether effective Friday.
Yes, sir.
Okay.
Thank you.
Thank you, Judge.
Yes, sir.
Thank you.
Court does call the case People versus Sierra McCoy Nobles.
Good morning, Your Honor. Edward Drukes on behalf of Sierra McCoy Nobles.
Your name, ma'am?
Yeah, I'm going over.
Thank you. This is a waiver.
That's correct, Your Honor.
Ma'am, you're waiving your right to a preliminary examination?
Yes,
And you understand that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
yes,
You understand you'll not have that here. You'll proceed to circuit court for further resolution.
yes,
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on counts 1, 2, and 3 with 4 following. Mr. Jurgens.
Your Honor, we acknowledge receipt of the information, stand mute, waive reading, and ask for a pretrial date.
Defendant in waive formal reading, standing mute to all 4 counts. Court will enter a not guilty plea. Pretrial will be set for July 17, 2025, 1:30 before Judge Slay.
Thank you, Your Honor.
Bond will continue. The cases of the people versus Brandon Carter. Didn't mean to wake you. No.
Lauren Brown, Deputy Chief Public Defender, appearing on behalf of Mr. Brandon Carter. It has been discovered that Mr. Carter has been lodged at the Monroe County Jail.
Oh,
But he is unable to make this court date. He'd love to, but
so he's currently lodged there?
that is my understanding.
Is that also the people's understanding?
My officer in charge.
Okay, so do we know how long he will be there?
No, I do not have that information as of yet, Your Honor.
We don't.
Well, why don't I do this then? I'll find good cause adjourn the preliminary examination. I can set it for the 3rd or the 24th of June, which would 24th. June 24th, 2025.
You don't have.
Then this is all messed up. Why? Oh, I can't. You're right.
Correct. You have the 17th in the afternoon.
I have the 17th of,
Yes, of June, because of Juneteenth. So it's PMs.
oh,
So June 17th?
June 17th, 2025 at 12 noon.
Would the court consider just a nominal bond in the event if he were to be released, at least he wouldn't drift off into the ether because he wouldn't necessarily have notice of this date? Obviously, we will work to rid him, but I don't know. He may get out of Monroe County Jail between now and June 17th.
Any response?
A very, very nominal bond, Your Honor. Like $10?
Brown, when have you ever known me to set a $10 bond? I think I did once. Still haven't seen that person. I'll set bond in both cases at 1,010%.
Thank you, Your Honor.
Thank you. Well, are we ready to go on something? Johnson's over there hiding in the corner. He's ready on this?
Yes.
He was over there hiding, but I saw him.
I'm not hiding, I'm just staying out your way.
What? Staying out my way? Why? I am one of the most enjoyable people I know. So why don't we, what we anticipate 3 witnesses on this one? Are the people ready to go on that?
I don't even expect one witness on the phone.
You expect 1? Okay. And you had one or two?
I have one, but Mr. Gaddy is off today, so he's not here. So
Is he council approach? Versus Lawrence Buckner.
Andrew Childers appearing on behalf of the people, Your Honor.
good morning, man. Please, this honorable court, Kareem Johnson, on behalf of Mr. Buckner, approaching and seated to my right.
State your name, sir. Thank you. All right. Date and time set for preliminary examination. You may proceed.
That's correct, Your Honor. The people are ready to proceed. You intend on calling one witness. Maybe the people call their first witness.
You may.
We would call Amy Hudson to the stand.
See you on the phone again. See you on his phone or no? Because you did that at the. Pardon? Council approach, please. Yeah, we're sworn.
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God? See, state and spell your first and last name for the record.
My name is Amy, it's Amee, my last name is Hudson, ASO.
All right, you may inquire.
Thank you, Your Honor. And just one other matter. My officer in charge, Deputy Von Heath, is present in the courtroom. He's the only other witness I have present. I don't intend to call him, but he is present.
All right, very good.
Miss Hudson, directing your attention back to the date of April the 1st of this year, 2025, were you in this courthouse testifying in a preliminary examination on a different matter?
Yes.
Okay. And was that in this very courtroom, courtroom C?
Yes.
Okay. And who was the judge at the time? Judge Washington? Okay. And was the defendant in that case, based on your understanding, Ms. Hudson, Mr. Buckner?
Yes.
Is he present in the courtroom here today?
Yes.
Can you identify an article of clothing that he's wearing?
He's wearing a black.
Okay. Your Honor, may the record reflect in-court identification of the defendant?
Without objection, record shows so reflect.
And I don't want to get into the facts of that case, but you were some sort of witness in that criminal case. Was that a criminal case?
Yes.
Okay. And you were a witness in it?
Yes.
Okay. And had you testified before Judge Washington in that matter on the date of April 1st, 2025?
Yes.
Okay. At some point, were you done testifying?
Yes.
Okay. After you were done testifying, what did you do?
I went and sat back down while they called up the next witness.
Okay. Where did you sit down?
I sat about where I was sitting when I stood up today, maybe one row up.
Okay, so we're making a transcription of this, so I'm gonna have to be.
It's on the right-hand side, probably in the third row back.
You're pointing in the courtroom, so you remained in the courtroom?
Yes, I remained in.
Okay, so you sat down in what we would call the gallery of the courtroom from where you are sitting in the witness stand on the right-hand side, and you said about the third row back.
Third row back.
Okay. And you did that while another witness was testifying. Okay. And at some point in time, did that witness stop testifying?
Yes.
Okay, what happened after that witness stopped testifying?
The judge asked for some more information and then she called for a break.
Okay. The judge showed up to take a break? Okay. Is that a yes?
Yes.
Thank you.
I'm sorry.
It's okay. And what happened when the judge stood up to take a break?
When they called the court for recess, he was on the left-hand side.
Who is he?
Was on the left-hand side. He stood up. He was around two people that had already started to be in the row.
I'm gonna just stop you right there. So you've said the left-hand side, that would be the left-hand side of the courtroom from where you are seated in the witness stand today?
Yes.
Okay. That would be the side that the defendants normally sit at?
Yes.
Okay. Where was the defendant seated?
He was in the first row back.
In the gallery?
In the gallery.
Okay, so he was not seated at counsel table?
No.
Okay. So the judge, the judge got off the bench and exited the courtroom?
Yes.
Okay.
Yeah, the judge, she did not exit the courtroom right away. She stood up, as they were calling. There was two people up front talking to her. And then when she got done speaking to them, that's when they called the recess. And he stood up.
He being the defendant?
The defendant, yeah. Went towards the middle. There was two people already going to go to exit. He waited until the sound went out.
Okay, when you say how do you know he waited until the sound went out?
Because he turned around and he looked. He stopped.
Objection, speculation.
I'm gonna overrule the objection. I'm gonna let her.
He stopped. He looked back. The minute
Hold on, look back at
the
where?
screen, he looked back at the screen to make sure the judge, to make sure that the judge.
I'm gonna just,
Okay.
I'll stop you there. We're gonna unpack this a little bit. And Judge, I understand the court's concern. So you observed the defendant. You said he stopped. Where did he physically stop?
In the middle.
In the middle aisle?
In the middle of the aisle.
Okay.
Yeah.
Where was he in the middle of the aisle, close to what we would call the bar or close to the back door of the court?
He was in the middle, like closer towards this side of
You're motioning the right side.
the right side.
Okay.
Yes.
But I'm asking you, distance wise, was he in this area or was he in the back part of
No, he was closer towards
the front? Okay. You are still, fair to say, you are still seated in the third row
still seated.
on the right, your right side of the courtroom.
Yes.
Okay. When the defendant stopped, is he looking at you or is he looking somewhere else?
When he first stopped, he was looking like straight ahead.
Straight ahead.
And then he.
And
Straight ahead toward.
Yeah.
Towards the exit door.
Towards the exit door.
Yes.
Okay.
And then when he stopped, he turned around and he looked.
And in what direction, when he turns around and looks, in what direction is he looking?
He's looking to see if the judge is.
I'm not, and so I'm not asking you. You can testify to things that you see, things that you hear, things that you witness. You can't testify to what someone else is thinking.
Right.
Okay.
No, he
So,
turned in the direction as to where the judge stand is.
okay. So just so we're clear, the defendant was looking towards the back doors of the courtroom. He then turned around and is looking in the direction of where the bench and the TVs are.
Yes.
Okay.
Yes, the bench and the TVs are.
At some point, does he then turn back around to look towards the back door?
Yes, he does.
When did he do that?
The minute the screen started making that sound.
Like a white noise sound?
Yes.
Okay.
Yeah, like
And
it's no longer.
And I will direct your attention right.
Okay, go ahead.
I'll direct your attention right now. There are screens on in this courtroom. You see those?
Yes.
And they're depicting the court and yourself in the witness stand. Is that correct?
Yes.
Okay. Did the screens look like that when the okay. What did they look like if
They
you look?
were like, as if cable went out, they were, there was nothing there. It said private.
Okay, it said private.
There's a black screen with private written in white.
Yeah,
Okay.
yes.
At that point, once the screens changed from showing the video of the courtroom to this private, what did the defendant do?
He walked on to the right-hand side, stopped to where I was sitting and made verbal threats.
Okay, he said something to you?
Yes,
What did he say to you?
he called me.
I'm gonna stop you right there.
Yes,
Hold on a moment. You mentioned something and I just need to clarify this. You said that there was static.
yes, sir.
What was that you're talking about?
There was no more pictures showing. It was just a like when you call up the lawyers to speak to you, the screen makes a noise. It makes it makes a noise. I don't know how to describe it. It's not it's not a silent noise. It makes a noise to where it's not recording anymore. Do you want me to sit down so you can turn it off?
No.
Okay.
I'm pretty much here every day. I'm just trying to figure out what you're talking about. You're saying it made a noise.
Yes, the screen went blank, and it's not like it's crushing out a noise. Like there's a noise
Coming out of the speakers.
Yes, coming out of the speakers.
Was it a constant noise?
It started, and then I'll be honest, I don't know if it was on.
Gotcha. Okay, just one other thing.
That's fine.
When you said Judge Washington was talking to two people, was she talking to two people in front of the bench or two
Yes.
people behind the bench?
No, two people in front.
So she was speaking to two people in front of the bench. All right. At the point at which she's doing that, can you hear that conversation?
No,
Okay, at the point at which she's doing that, do you hear anything in the courtroom?
no. I mean, I can hear people talk, but not up front. I mean, just what, people may be saying as they're sitting on the gallery.
Right, but do you hear anything else?
No,
Okay. And she had that conversation and then turned around and left.
yes, yep, they call.
At the point that that happened, what was on the screen?
Before, when she got done speaking to them,
Not as she's talking to them. What's on the screen?
there's nothing on the screen.
All
And
right.
then she got done speaking, then the video came back up before they called recess.
And when you say the video came back up, the video like it is right now?
Yes, and
Okay.
it just showed her on the bench. There was no one on the stand.
Okay, go ahead. So at some point, as we've discussed, the defendant then turns and is walking, now facing back towards the back door,
Yes.
which would also be in the direction that you are in relation to the defendant.
I think he's just recapping what she's saying, so I'll overrule that. Go ahead.
Yes,
Okay. And you had previously said the defendant said something to you.
yes.
Okay. What did he say to you?
He called me a lying bitch and told me that that he was gonna get even, he was gonna get me. That was the last thing he did. He was gonna get me.
Did you say anything in response to that?
No,
How did that statement by the defendant make you feel?
correct.
After he made that statement to you, where did the defendant go?
He turned around, looked back one more time.
I'm going to stop you there just so we're clear. So the time he's talking to you, is the defendant looking towards the back of the courtroom or the front of the courtroom?
He's looking he's looking at me.
Right.
At the exit.
Okay, so he's facing away from where the judge would sit.
Yes.
Okay. After he makes that statement, you said he turns around?
Yes,
Okay. When he turns around, in what direction is he now facing?
he's facing back towards the front where the judge would be sitting for
Okay.
this area.
At the time he turns around, is the judge on the bench?
No,
Okay. If you recall, at the time he turns around, who would be on, and I'm motioning on the other side of the bar, who were there attorneys or people present?
yes,
Okay.
yeah, his lawyer was still on the left-hand side. You guys are still on the right-hand side.
You guys being someone from the prosecutor's office?
Prosecuting,
Okay.
yes. And there was one officer also on the right-hand side, and there was one officer sitting out in the galley, like 2 up from me.
Okay. So the defendant makes a statement to you, he turns around and he's now facing back in the direction of where the judge would sit, and what happens next?
The minute he saw that his lawyer was coming out, he turned around and took out the exit door.
Okay.
So again, speculation of what my client saw.
Okay. I would agree. So
Let me ask-
his lawyer, what you saw, ma'am, was his lawyer starting to leave and then he left.
Yeah. the minute
That's
he
what
saw-
you, no, that's what you saw.
Yes,
Okay, thank you. I think that corrects it. That's what
Go
ahead.
And did you remain seated in the gallery of the courtroom, or did you exit the courtroom at that point?
I remain seated.
Okay. And at some point after this fact, did you bring what had happened to someone else's attention?
Yes,
And who was
it
that?
was one of the police officers.
One of the police officers present in the courtroom?
Yes.
Okay. After you made contact with the police officer, did you have any further interactions with the defendant, Mr. Buckner? Okay. Certainly not in the courtroom,
Right,
correct?
right.
Okay. Anything in the hallway of the courthouse?
No,
Okay.
no.
Mayor, one moment, Your Honor.
Ma'am. While you do that, ma'am, you said you were seated in the third row. How far in on that third row were you?
Right there where the gentleman is with the black sweatshirt.
So you were seated on the end
Yes.
toward the aisle.
Yes.
Okay.
I have no further questions, Judge. Thank you.
Cross-examination.
Okay, ma'am, so you were here to testify, and if you remember, was that in case number 25 FB 1106, if you know?
I have no idea.
Did you get a subpoena to come to court and testify in that
No.
case? In that case?
I did not get a subpoena.
Okay.
They asked me to come and testify.
Now, it's my understanding that you're indicating that you are
Picking
sitting
him up. Picking him up.
in the gallery of the courtroom right here.
Wow. Okay, yeah, gotcha.
Is that correct?
Yes.
And you said that there's a member of law enforcement 2 rows up, sitting right here, where there's an individual with a sheriff's shirt.
Yes.
And your testimony to Mr. Buckner comes down the hall, the aisleway, stands at that same pew where the law enforcement officer was and issues a threat to you, which would have been within 15 feet of the law enforcement officer.
I never said that. I said he stopped at where I was sitting and said something to me. I never at any time said anything that he stopped where the police officer was sitting at the pew.
So when he stopped, he was at your row,
Yes,
Picking him up.
but there was still a law enforcement officer 2 rows up.
yes.
Was there other law enforcement officers in the courtroom like there are today?
There's one sitting up in the corner, up here on the right-hand side, where the gentleman is with the glasses.
When any of, I'm sorry,
Sitting where?
The gentleman with the glasses over here,
Mr. Bird?
yes, that's where the other.
Oh,
officer-
on this side? On
Yes.
this side?
On this side.
On the right? Okay,
Yes.
go ahead. Go ahead, counsel.
when this statement was allegedly made, none of the law enforcement officers in the courtroom jumped up and said anything?
No,
Now, you indicated that after you testified, you stayed in the courtroom.
yes.
Was there a sequestration order that, was there an order that you leave the courtroom after you finished testifying?
No,
Okay, so you heard the testimony after your testimony.
Yes,
Mr. Buckner's lawyer at the time challenged the accusations that you made regarding Mr. Buckner, correct?
In which case?
In the case you were there to testify about.
Your Honor, I would object to what that other lawyer did. That would be hearsay.
I'm not asking for
Well,
what,
she's asking, I'll overrule that. I mean, he's not asking what she said. He's just asking what her impression of what he did.
right.
So go ahead.
His lawyer in the case you were there to testify on was challenging you on the assertions, allegations you made about Mr. Buckner.
for that case?
Yes.
Well, I mean, I don't know if he was challenging me, he was just questioning me the
Okay.
same as you are.
And there was another witness that came up to testify after your testimony, correct?
Yes,
You heard that witness's testimony.
yes,
You were there when the preliminary examination ended, correct?
yes,
That Judge Washington, found that there was no probable cause that Mr. Buckner committed a crime. Correct.
I would object to the relevance of that.
Well, Your Honor, the relevance is they've charged my client with intimidating.
I'm going to overrule the objection.
Yep.
Go ahead.
Judge Washington found that there was no probable cause to believe that Mr. Buckner committed a crime after you testified, correct?
she also stated that it can be called back up if they get the proof that they need.
Okay, which is fair. All right. So after you made accusations about Mr. Buckner pointing guns at people, correct?
What does that have to do with this?
Ma'am, I don't.
Answer the question, ma'am.
Yes, I did.
You made accusations that you saw him deliver crack from a great distance away? You didn't make the accusation? Did you make an accusation that you saw him point a gun at somebody?
Yes.
Okay. No further questions, y'all.
I have no redirect, Judge. Thank you.
All right. Ma'am, how long did it take you to report this to somebody?
Within minutes.
Where was Mr. Buckner when you reported this?
He had walked out of the courtroom.
How long after he walked out of the courtroom did you report it?
Within probably 2 minutes, if even that,
To whom?
to the police officer passing by.
Which police officer? Is that officer here today?
Yes,
Okay, and that's who you reported it to?
yes.
That interaction, and if you look back on the right-hand side where the gentleman seated in the black shirt is, you're saying that's where you were sitting.
Yes,
When Mr. Buckner came down the aisle, you'll notice that the back row is basically a handicap accessible row or a non-handicap accessible row. You see that where it extends out?
yes.
How close was Mr. Buckner to you when he's making these comments?
He was past where the gentleman is sitting with the black sweatshirt, and he was in between that row and the woman sitting right behind him. And he leaned back and
And he leaned back.
He was, yeah, turned his head back and spoke to me.
So because that's a little bit different than what you told me before, because you're saying that he was where the gentleman seated in the black
Right.
he was past him toward the door.
No, right, there's right where he's sitting, right there, at that spot, right there. It's like there's a spot, where you, not where you would enter, but where would be if you're standing beside. So closer towards the opening of the back row.
So he's standing closest to the opening of the back row.
Right, but he's beside where the gentleman is with the black sweatshirt. And that's where.
But he's over on that side of the courtroom?
Yes,
So ma'am, are you telling me he's no longer in the middle aisle?
No, he crossed from the middle aisle to over to stand closer towards the right-hand side. He's no longer in the middle. He's standing like as if you're having a one-on-one private conversation with somebody.
And how loud were these comments you say he was making?
They were not very, I mean, other people were walking out of the courtroom. I could hear them, but it's not like he was screaming them. They were normal voices.
When you testified in the previous matter, was there a victim's advocate assigned to you?
Yes, there was a victim's advocate.
Okay, so after you testified, did you talk to that victim's advocate?
No. They asked me to just go sit into the courtroom.
I want to go back, ma'am. At the time that you say Mr. Buckner got up, what's on the screens in the courtroom?
The screen was still on to where you could see where the judge was sitting. And then she called her a conference. And then the screen went blank. And then the screen went back up to where you could see where the judge was sitting. And then she called for a recess.
And then what happened to the screen when she called for a recess?
And then the screen went blank. And said, right, it didn't show any pictures, didn't show any people anymore.
Prior to the judge taking recess, was it Mr. Buckner's other case that was being heard, the case that you were there for?
That case had been heard, and then honestly, as another case was heard, there was a witness, but I think he was sitting out in the galley, and I think that they had started to call for another case. Because I don't think that.
Had your case that you were there on, had it concluded at that point?
Yes, because he was sitting out in the galley.
Okay. So then my question is that case had concluded?
Yes.
The judge had made a ruling?
No, she had asked for some more information, and they had set it aside for a minute and was going to call it back up.
And so had they called another case?
Yes.
Was Mr. Buckner's attorney on that case?
No, he was sitting on the left side, where the gentleman is behind his lawyer right now where the glasses is.
So he had moved back to the chair?
Yes.
But during Mr. Buckner's case, he was at the table with Mr. Buckner.
Yes,
From that period in time, that case ending until the judge took a recess, approximately how much time was there? Mr. Buckner, you said was in that first row, right?
yes,
How far into that first row was he?
like right on the end.
So he's right on the end, seated where I guess the young lady in the pink would be.
Yes, hi. I'm sorry.
Sorry to use the people as props, but that's where he was sitting?
Yes,
Okay, so he's sitting right behind his attorney.
yes,
Okay. And then at some point he gets up
yes.
and walks back. Were you the only witness that had testified in that previous case?
No, it was me and one police officer,
Okay.
but I was the only.
Where was the police officer that testified?
He was sitting over, on the right-hand side where the gentleman is with the glasses.
Did he testify before or after you?
After me,
He testified after you.
yes.
Was there another witness then?
They stopped because the judge asked for information. So they were pausing it to see if they could collect the information that was needed to proceed with the case.
So just so I'm clear, you were the first witness to testify, right?
Yes,
The next witness was a police officer.
yes,
And all during that time, Mr. Buckner is at the table where approximately where he is right now.
yes,
Then at some point, there's a break. Mr. Buckner leaves the table
yes.
and is seated in basically the first seat in the first row behind defense counsel.
Yes,
Then another case is called,
yes.
right? And was it the attorneys? Was it the attorneys on that next case? Was that who the judge was talking to?
Yes. I don't know if it was I mean, it was someone from the state and then someone representing that person. So yes, that's who the judge was talking to.
They were the attorneys on the next case.
Yes,
Okay, and the judge spoke with them.
yes.
As the judge is speaking with them, what do you hear in the courtroom?
The noise coming from the speaker and
What noise?
the, whatever that noise is. I don't know how to describe it,
Okay,
but just so we can't hear what's being said up here at the level.
okay, so you hear that.
Yes,
At the point that you hear that, where is Mr. Buckner?
still seated.
Okay. The judge then leaves that session, gets up to walk out.
Right, but the screens turned back. When they went back towards their tables, the screens went back to where you could see the judge. And then they called recess.
All right. At the point that they call recess, where is Mr. Buckner?
That's when he stands up, goes towards the middle of it, and then there's two people, he goes, and then that's when he stops. There's two people getting out like in the next row.
How many people were behind Mr. Buckner in the gala?
Honestly, I don't know. I mean,
How many people were, was there a person sitting behind you?
I don't think so.
Was there a person next to you?
No.
Was there a person in front of you? Which would have been in the second aisle?
I don't. If there was, I think.
Didn't ask that. Do you know whether or not, okay, do you know whether there was a person 2 aisles up?
Yes.
Who was,
Police officer.
and how far over was the police officer? You're saying where the gentleman that just sat down in the blue tie would be? Mr. Warren Green,
No,
that's your.
further over. He's probably where the other officer is, if not closer towards.
So
the wall.
he's further over toward the wall.
Yes.
Is there anybody else in that row that you recall?
No.
Is there any, so where you are, you're saying there's nobody in your row?
Not that I remember, but not that I remember.
Behind you, you're indicating that there's nobody behind you in that row.
Not that I remember.
In front of you, the row would be directly in front of you. There's nobody in that row that you recall.
Not in front of me, there was someone down.
There was what?
There was someone down closer towards like where the gentleman is with the blue tie. There was two people right there.
There were two people right there?
Yeah. They weren't towards the edge, they were like in the middle down.
When Mr. Buckner allegedly makes those comments, do they turn around?
I was not paying attention. I just put my head down and just let it happen.
Council, I know, council approach briefly. This is too much. There was a. All right, let's go get that. So what I'm gonna do in this case is, and I talked with counsel, I'm gonna take a brief break. Get some information, get it to counsel, and then continue the hearing after that.
May this witness be excused or is the court obviously appropriate if the court wants to inquire based on reviewing the video?
Yeah, I don't want this witness excused at this point because I may have questions and the video also may give rise to questions from Mr. Johnson. All right. So we'll pause in this case. You may step down, ma'am. And I'll call you back up and court's gonna take a brief recess. And I know people want to talk to me, but court's gonna take.
Mr. Milan and I were hoping to approach.
Yeah, but court take a brief recess.
All rise.
I'm not up. None of that was caught. All right. State of Michigan versus Lawrence Buckner.
Andrew Childers appearing on behalf of the people, Your Honor.
Good afternoon, Kareem Johnson, on behalf of Mr. Buckner.
All right. We had finished that witness. Do people have a motion?
And I guess just for clarification, I don't think we technically finished the witness.
That's true.
So if the court is satisfied, I have no further questions for that witness.
Okay.
No further questions, Your Honor.
All right. Very good.
We'll have no further witnesses. The people will rest.
All right. Any witnesses for the defense?
No, Your Honor.
All right.
Your Honor, at this time, the people would move to bind the defendant over as charged on the one count of witness intimidation based on the testimony of our one witness. Obviously, the court has provided both myself and Mr. Johnson copies of the video. Because our county issued laptops don't have CD discs, wasn't able to watch it myself, but I know the court has watched it, and I trust the court's judgment in reviewing and will respect the court's decision in that. And so, thank you.
All right. Checked.
Your Honor, for the testimony, reasons stated on the record through cross-examination and the video that I asked to be admitted as defense exhibit A. I'd ask the court to not bind this matter over.
All right. The court will admit without objection exhibit A. In this matter, the court was very specific in questioning Ms. Hudson with regard to where she was at particular times and the like, to try to get a sense and feeling as to where Mr. Buckner would have been at any given time. The long and short of it is, when I review the video, it is clear Mr. Buckner is not seated in the first seat. He's actually seated in the second row back. And he's sitting there. We can pick up Mr. Buckner, and I'm looking at it. When I time what portions of the video, well, let me make this clear. There are points at which, when the court goes into recess, there is no video. So in looking at it, the best the court can as to the timing of when the events would have occurred, it is clear we see Mr. Buckner in the courtroom at a particular point. No doubt. He's in that second row, sitting there. He's second row, basically second seat in. At the point at which Ms. Hudson indicates that this occurred, Mr. Buckner is not in the courtroom. And that doesn't mean that it may not have occurred at another point. However, the testimony that I have in this case, it couldn't have happened. Mr. Buckner would not have been in the courtroom at that point in time. So with that finding, and the court having reviewed that, the court's going to find that there's no probable cause to bind this defendant over on this charge. These charges are dismissed. Thank you. You don't want to take it and keep it?
No, sir.
Yes. Go over. It'll be entered in the system. We'll call over and make sure that, just get over to community corrections.
I gotta go to the other courthouse, and I gotta be there too, so I can just walk across the street.
To do what?
Tether off.
Yeah, you can go over to community corrections. All right. If they give you a problem, tell them to call over to my court, and we'll let them know. All right, thank you. For Mills. While we're bringing that out, let me have their case, Slandy's case, and the 11 o'clock.
Yes, I'm sorry.
I told him I'd call them. Hang on one thing. Court does call the case of the people versus Jillian Carey.
After one of the people.
Good morning, Your Honor. Michael Bellotta, on behalf of Jillian Carey, who's present to be in court.
In this matter, record should reflect that a bench conference in this case, so.
That's correct, Your Honor. We spoke at length in chambers about this case and its potential alternative resolutions thereof. So we are requesting an adjournment to June 17th to allow for a time to explore those potential alternatives, as well as to have hopefully sufficient time to have expert witness Kevin Parvis testify.
Yes, that's correct, Your Honor.
All right. I will adjourn the preliminary examination then to June 17th, 2025. That's at 12 noon. All right.
Yes,
on that day.
thank you, Your Honor.
All right, thank you. Bond will continue. Thank you.
Yeah.
Court calls the case of the people versus Tybee Mills, 3 cases.
Andrew Childers appearing on behalf of the people.
Good afternoon, Your Honor. Evan Bassan, P71061, on behalf of Mr. Tybee Mills, coming to the podium. Mr. Mills, please state your name for the record.
These are all going to be waivers.
That's correct, Judge.
All right. Mr. Mills, it's correct that you're waiving your right to have a preliminary examination in these matters?
Yes, sir.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed. You understand that?
Yes, sir.
You understand you will not have that hearing and that you'll proceed to circuit court for further resolution of these matters.
Yes, sir.
People also waive their rights.
Yes, Your Honor. Thank you.
Preliminary examination having been waived, defendant is bound over to circuit court on all the felony counts with the misdemeanors following. Counsel, you acknowledge receipt of the information.
I do acknowledge receipt of information, Your Honor.
You waive their reading.
And we do waive a formal reading, Your Honor, this time.
And your client stands mute to this.
And stands mute, Judge, yes.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in these matters will be set.
June 2nd at 1:30 p.m. with Judge Hamud.
June 2nd, 2025, 1:30, Judge Hamud.
And Judge, I know we just did waive the exam, Judge, but may I briefly address bond, Judge?
You may.
So my client has been in custody since the arrest in this particular matter. I understand that these are serious charges, Judge, but I would also note that my client technically does not have a extensive or criminal history, Judge. His family is in court today. His bond right now is $500,000. Yeah, now I'm asking for a significant bond reduction. He's been unable to post bond. He was working prior to being incarcerated, Judge. His employment is definitely in jeopardy. Again, Judge, I know one of the charges is a capital offense. But Yana, I'm asking the court to at least consider, if possible, Judge, a $100,000 bond in this particular case, Judge, as opposed to $500,000. I believe that that's still a significant bond to post. If he's able to.
How much did you say?
I'm asking for at least $100,000 as opposed to $500,000.
All right. I'm sorry, I interrupted.
Oh, and so Judge, I just think that that's still a significant bond to post if he's able to post it. But Judge, $500,000 is unattainable at this time, and I also believe that at this time it's excessive given the circumstances, John.
Yeah, the people respectfully request that the bond remains currently set. The most troubling is that there are two. There's an armed robbery, which is a capital offense that people were able to proceed today. We brought in the victim, in the Marine Corps from North Carolina. He's present in the courtroom, so that is obviously a capital offense. It did involve in that instance the defendant in possession of a firearm. The oldest case involved a LawNet investigation. It subsequently conducted a search warrant. The defendant was ultimately found in possession of distribution quantities of methamphetamine, firearms, as well as 3D printers, items used to make what are commonly called ghost guns, as well as lock switches to modify the guns. And then when the police went to arrest him on the older warrant, and this was back about 6 weeks ago, the defendant attempted to flee, was in his vehicle, involved in a pursuit involving both the state police as well as Pittsfield Township Police Department, and was again found in possession of a Glock with an extended magazine and more controlled substances in the search, and that yielded other items associated with the modification of firearms to make ghost guns. All of that is both very troubling from a community safety standpoint, as well as the defendant's potential posing a flight risk. So I would ask that bond remains currently set.
Anything else?
Judge, even if the court would impose a tether, Your Honor, or house arrest, just the opportunity to at least post a bond in this case, the 500,000, if it's excessive. And again, Judge, I think even with everything the prosecutor just mentioned, I think $100,000 cash bond is still a significant bond to post and gives him a huge financial stake in his bond that he wouldn't not comply or be a danger to the community or be a safety risk in any way, shape, or form, Judge.
Well, I would consider the defendant to be a safety risk, given at least the allegations that are contained in is represented by the people in this case. I think that given all of the circumstances, his bond is set appropriately. I will deny the request for a bond modification in this case. You can take it up before Judge Booth.
All right, thank you, Judge.
All right, thank you. Court calls case of the people versus Julian Tabron.
Thank you, Your Honor. Alex Warren Green on behalf of Mr. Tabron. Mr. Tabron, state your name.
Julian Tabron.
All right. I have in this case a plea form that indicates that the defendant will be pleading no contest to an added count 4 of larceny 200 to 1,000, the 1-year offense, and also an added count 5 of breaking and entering illegal entry, a 90-day offense. Upon a successful guilty plea to counts or no contest pleas to counts 4 and 5, counts 1, 2, and 3 would then be dismissed. That's the court's full understanding of the agreement.
It's our full understanding, Your Honor.
Yes, Your Honor.
All right, very good. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony about to give to be the truth, nothing but the truth, so help you God?
Yes.
State your name. Julian Tabron.
Put your hand down. Sir, it is this court's understanding that you're going to plead no contest to 2 charges. Is that your understanding?
Yes.
First of all, it's this court's understanding you're going to plead no contest to the charge of larceny 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased if 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, Your Honor.
The other charge is the charge of breaking and entering illegal entry. That's a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. You understand that?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor.
2 things about it. I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest these charges. You understand that?
Yes, Your Honor.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
Mr. Warren Green, the basis for the no contest plea.
Potential civil liability, Your Honor.
All right. Sir, to the charge of larceny, 200 to 1,000, how do you plead?
No contest.
To the charge of breaking and entering, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form?
Yes.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights in that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No. No, no.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce?
No, Your Honor.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
All right. Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 25395. Any objection to the court having reviewed that report?
None from the defense.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine a defendant's guilt of this offense. Counsel, have I complied with the court rule and would it be proper to accept this defendant's plea?
Yes, Your Honor. There is an additional agreement that I failed to mention earlier. As it relates to restitution, the defense would stipulate to restitution up to the amount of $7,030. Your Honor, there's outstanding property that is going to be returned. We have agreed with the prosecution that property will be returned to the Pittsfield Police Department so that it can make its way back to the owner. And restitution may reduce from that point, but at this point, we stipulate up to the $7,030.
That's a correct statement.
Yes.
All right, just since it's coming to me, I just want to make sure I understand this. The maximum amount is the $730, $7,030. As property is returned, that somehow is going to be evaluated and it will come off of that amount.
The laptop, if it's returned, would lower that.
Pardon?
I said if the laptop is returned, it would lower that.
The laptop is valued at about $1,000, Your Honor, so we anticipate that the people's request will modify to $6,030.
Got it. Okay, so it will not, okay. I just want to make sure I'm clear. It will not go below $6,030, but it won't go higher than the $7,030.
That's our understanding, Your Honor.
With that, all right, so let me. Okay, have I complied with the court ruling?
Yeah.
The defense is satisfied.
Court will accept the defendant's no contest pleas. Counts 4 and 5, counts 1, 2, and 3 are dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
June 11th.
June 11th, 2025, 9 a.m. That's before me. Bond in this matter will continue. Thank you. All right, Mr. Tabron, on your way out of the courthouse, on the left-hand side will be my probation department. You can stop in there to start the process. All right?
Okay.
Thank you.
Thank you, Your Honor.
You know what it is. The cameras, yeah, it's gonna have to be flatter somehow, but the problem is that the cameras at the top, not the side.
So my understanding is we're down to the last 3 defendants and we're holding on all.
Holding on all of them. It's his phone.
He's part of the problem.
Okay. All right. Thought I'd ask. Okay, who else is?
So this is Ms. Senda and Mr. Bird. We also have Ms. Douglas. The other 2, Ms. Douglas and Mr. Brown, and then.
So Ms. Douglas and Mr. Brown?
Yes.
Oh, that's gonna be funny. No, I'm kidding. All right, well, who's,
And then Ms. Douglas and Mr. Warren.
seems to be a common problem here, Ms. Douglas. No. All right, let's,
Mr. Bird.
is Ms. Zendara? Oh, there she is. All right, let's do that. Get counsel out. How many witnesses?
Maybe 2 on the Arno file, 1 on the home invasion.
Got it. Court does call the cases of the people versus Devon Gibson.
Ally Zend on behalf of the people, Your Honor.
Yes, Your Honor, please, Your Honor, report again. Brandon Bird on behalf of Devon Gibson. Gibson, can you please state your full name for the record? Devin Gibson.
All right, thank you. All right, there are 2 cases here, set for preliminary examination. We're ready to proceed.
Yes, Your Honor. And at this time, the people would be withdrawing their motions for forfeiture by wrongdoing and would be ready to proceed.
All right, very good.
I'm ready to proceed, Your Honor. I do think it's a little preliminary matter that you might want to discuss before taking the record. We won't have, the only complaining witnesses that we have is the police. And the people did make me aware that they were trying to introduce, a couple 911 calls. So I believe,
Can we approach, Your Honor?
911 calls on what?
Can we approach, Your Honor?
Counsel, you may want to, while you're talking to your client, press the button on that and you gotta hold it down because it's gotta be green so we can't hear you.
Just hold it.
Hey,
You ready?
I still relate to the 911 calls in.
All right, very good. All right. Ready to proceed on this? You may proceed.
Thank you, Your Honor. We start with the case. Name is 1110.
Yes, sir. Yes, ma'am.
Thank you, Your Honor. The people would first call Deputy Gerwig to the stand, Your Honor.
Sir, please come forward and be sworn.
You take a seat, raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so? State and spell your first and last name for the record, please.
Deputy Brian, Gerwig.
Good afternoon. Deputy Gerwig, what do you do for a living? And how long have you been employed there?
3 years this year.
And I'd like to direct your attention to March 14th of 2025. Were you working that day? What shift? And were you in a marked patrol car? And were you in uniform? And on that date, were you dispatched to the area of 8517 Cargo Drive? And is that in Ypsilanti, Washtenaw County, Michigan?
Yep.
And what was the nature of that dispatch?
It came out as a domestic incident. Caller was third party, was the father of a female, saying that his daughter and her boyfriend were getting into the apartment.
Okay. And did you come into contact with anyone on scene? Who?
The caller, well, I identified as caller as just print off.
Okay. And how did he appear to you?
He was upset, visually upset. He did have blood on his forearm.
Okay. And did he want to report an incident to you? And when did this incident occur in relation to the statement he gave to you?
Just almost before, probably 5 to 10.
Okay. And was there anyone else in the residence at this time?
At the time.
Okay. And you said a 911 call was placed?
Correct.
And do you recognize this? And what's contained on this flash drive? And did you review the contents of the flash drive before this hearing? Okay. And did you recognize a voice on that call? Whose voice was it? Your Honor, the people would move to admit people's proposed exhibit 1.
Any objection or what, or I think by stipulation here.
Okay.
All right. Exhibit 1 is admitted.
Thank you, Your Honor. Can I plug it in?
Yep.
Okay. Oh, man.
And what's happening?
I think you should know.
I don't know. Hold on with your daughter. Hold on with your daughter.
They didn't do me.
Is it an apartment number there or is that a house?
No, that's the address, townhouse.
Okay, and when you say she
Yes, I'm 7 years old, welcome, because something is running all over me.
Okay, hold on, has somebody been physically assaulted?
Hold on.
They assault each other,
Yes, ma'am.
and do they need an ambulance?
No, the kids can't even be still fighting in my house.
Okay.
Give me that dog. Come here, hold on. Come on. No, come on, boy.
Has anybody been taking your training today?
Not right now, I will.
What's your name?
My name is Richard Flynn. Please.
We've got the phone in, okay?
Thank
Where
you.
are they now?
Thank you.
Where are they now?
Hold on, moving on.
What is the male name?
Oh, thank you.
How do you spell that last name? We're not almost getting them on the way. What is his name?
You talk about camera. If you don't talk about camera, come on. If you don't talk about camera, come on. Come on. Come on. Let go. Come on, back down, man. Come on, come on. Hold on, come on. Very guilty, you You gotta be. You gotta be. That's what we.
G-I-V-S-O-N.
But,
What's his first name?
but,
Spell that for me.
he always,
We don't know how old he is.
18 months from now.
Is he a white male, black male, Asian, Hispanic?
But,
Did he hit your mother and she fell on the floor?
we picked up trash, you know,
Say that again?
picked up trash, and she hit her head on the floor. I see you out that way, but you need to give me, because I'm trying to call, I try to do it, here we go.
What, are they on foot or do they have a car?
They're in the car.
What kind of car?
It's brown apple.
Oh, they don't, they're on foot?
Yes.
What's he wearing?
Black sleeves, black sleeves, and black and white shoes.
Black and white shoes?
Yes.
And you left with him?
Yes, as soon as you all time, I can do this.
And when did he leave?
Routine, a great teacher.
Great teacher.
Great teacher. What's wrong with this time?
And she was still articulation.
Stop. Like,
Her name.
Mr. Prince.
Spell that last part.
P-R-I-N-C-E.
Okay. So she left with him. Do you know which way they headed or where they're going?
I can't get the dog. So, hopefully, the dog will be here. I'll be in the office.
Will the lack of the dog before police get there?
I'll just do that. I just can't do it anymore. Yeah, go back to the road, he can come in. I'm just thinking, I can't do it. I can't do it. You don't understand. I can't do it.
Do you want us to have an answer for your daughter?
No, you don't touch it. Because pick and pick her up, because pick her up and she fell like that.
They come back or they change their when they get their life to help bring their
So going back, you said Lucius wanted to report an incident. What incident did he want to report?
The assault between his daughter and Devin.
And what did he say happened?
So Devin picked her up, slammed her on her head.
In your it's a present sense impression of what he just saw happen after police got there.
Gonna go loud in. Go ahead.
So he reported, what did he want to report?
Assault between his daughter and her boyfriend.
And what did he say happened?
So Devin, which is his daughter, would send his boyfriend, picked her up and slammed her on the head in the apartment.
And did he say anything else happened?
That they got into it, that he was, he tried to break them up.
And did he say what happened to Lucinda after she was slammed to the floor?
Said she lost consciousness, she was just laying there.
Okay. And when you arrived at 8517 Cargo Drive, did you take any photos of the scene? Your Honor, may I approach the witness of People's Proposed Exhibits? I guess I could change these. 2 through 4.
Yes, you may. Let me just ask this, officer. When you arrived there, who were you speaking with?
On scene, sir?
Pardon?
I was talking to the father, Evan's girlfriend's father, yes.
All right.
The person I called.
And how did he appear at the time that you?
He was distraught, upset.
All right.
Trying to tell us what was going on. He had some, what appeared to be blood on his arms.
All right, and that was approximately, I think you said 5 to 10 minutes after the incident had occurred. All right. So just so the record is clear, I'm allowing it either in the present sense impression or as an excited utterance, given that he was under distress of the situation at the time. So go ahead, Coach.
And may I approach the witness?
You may.
And what did I just hand you?
Picture of the scene of the residence that I took.
And are these a fair and accurate representation of the scene as you observed it on March 14th?
Right.
Your Honor, the people moved to admit exhibits 2 through 4.
Any objection or voir dire?
Objection.
Exhibits 2 through 4, 2, 3, and 4?
Correct, Your Honor.
2, 3, and 4 are admitted.
And may we publish them to the court, Your Honor?
Yes, sir. Thank you, sir. Go ahead.
And do you know Devin Gibson? Is he in the courtroom today?
Yeah.
Can you briefly describe where he's sitting and something he's wearing?
Sitting left, north to the right of you, wearing that one.
And Your Honor, please let the record reflect that this witness has made an in-court identification of the defendant.
Record shows so reflect without objection.
So during that same shift, at some point, did you find yourself at 8695 Spinnaker Way? And how did you come to be at that address?
A separate caller, in no relation to the original call we were on, saying that there's a male and female in the locker room that's arguing.
Okay. And what happened when you got to that address?
We made contact with later that Devin and Wasanda.
Okay. And did you interact with Devin when you arrived on scene? And did additional deputies arrive on scene? What other deputies?
Deputy Russell, Sergeant Howe, Deputy Hill.
Okay. And what interaction did you have with the defendant when you arrived?
He was not educated. He was in the line with Wasanda, who was active.
Okay. And did you take any action toward the defendant at this point? What action did you take?
And it was an attempt to detain him pending further investigation.
Okay. And at this time, were you wearing a department issued body worn camera?
Yeah.
And was it activated in recording? If I get a little moment, Your Honor.
Yes. Good job.
Yeah.
And do you recognize this?
Yes.
What is this?
It's
And is this a fair and accurate representation of what you saw that day? Your Honor, people would move to admit people's proposed exhibits. It's 2 clips from the body camera. I believe 5 and 6.
Any objection or voir dire? Exhibits 5 and 6 are admitted.
Thank you, Your Honor. May we publish to the court?
Yes.
understand, I'm being wrong charges. This shit right here, bro. No, bro. No, ain't put it in there. Y'all put me straight, y'all put me straight, bro. I was in the same, that's why I started thinking of, bro. I was in the same, I watched her thinking of. Why don't treat me like this, bro? Why don't treat me like this, bro? Why don't treat me like this, bro? Why is I doing me like this, bro? Why do I take the fuck? I need medical attention, bro. I'm making fun of them. Why is I doing me like this, bro? Why?
So after you arrested the defendant, what did you do next? And then what happened next?
He began to kick the back passenger door.
Where were you taking him once he was put in the patrol car?
Jail.
Okay, and so what happened when he was being transported?
He kept kicking the back window. Once he kept asking what his charges were gonna be. We advised him that one of the charges was gonna be property from the vehicle because he on the scene of Spinnaker, he kicked the door so hard, he bent the door off his frame. Once he was advised of that, he said that if he's going to jail for damaging property, he's gonna damage property and kicked out the back window.
Okay, and at this time that this occurred, was your in-car camera on at the time? And it was on and activated? And do you recognize this video? What is this?
Our cameras of the person.
And is this a fair and accurate representation of the video that your in-car camera recorded of your patrol vehicle?
Yes.
Your Honor, people would move to admit people's proposed exhibits. I'm sorry, I think I lost count. Were we at
We'd be at 7.
7, 8, 9, 10, 11, and 12?
Okay.
And these would also be in clips, Your Honor.
7, 8, 9, 10, 11, and 12 are.
Thank you, Your Honor.
Wash our face off, we can get clean stuff up. That shit weird, bro. So weird as fuck, bro. Y'all gotta clean that shit. I hope that shit get on with you out there too. Real shit. That shit shit weird as fuck, bro. I just walked in, put a whole gun on my face, bro. Y'all gonna take me to jail for a fucking empty on me, bro? Y'all said for 1 ounce, so for domestic violence, for 1 ounce, resisting arrest. So you gonna, that don't make no sense. Y'all dumb as fuck, bro. And you try to bitch, you chick bitch. I know why you don't like me, because you used to cut my mama off, and you're a fucking chick, nigga. You're a fucking chick, nigga. You're weird, nigga. But you was the main one twisting my arm and doing that lame ass shit. But y'all don't be sneaky fucking around tomorrow on that shit, bro. Without that ass fucking wrong, bro. Put on fucking deal, bro. That's it, right in the shit, bro. And I gotta, yeah. Like, fuck that, bro. Let's go get the fuck away. Let's go get the fuck away. I'm fucked up. Dog, weird ass shit, bro. I'm still putting on my list, and I ain't got no medical shit. Oh. For NDOP? I'm saying, do I got NDOP on it? So I got it, right? Yes or no? NDOP. That's, I told somebody to break out your window there, right? Right? I'll jump. See, why y'all wanna do stuff like that to me, bro? Why y'all wanna do? When y'all want, I'm gonna jump out. I'm jumping out. I'm jumping out. Yeah, nigga. Yeah, nigga. Why y'all wanna do that to me? Why y'all wanna do that to me, though? Why y'all wanna do that? I'm gonna swing out. Yeah, nigga. Y'all weird as fuck.
And your apologies, it would be, the last one would be exhibit 11, not 12.
11.
Correct. So after this, was your patrol car damaged?
Yes.
Did you get an estimate for the cost of those damages? About how much was that estimate? And did you provide this estimate to the people? Your Honor, may I approach the witness of People's Proposed Exhibit 12?
12. Any objection to 12?
No objection.
12 is admitted.
And may we publish that to the court, Your Honor?
Yes, sir. Got you calling up.
Your Honor, may I have a moment?
You may.
Thank you. Nothing further from the people.
Cross-examination.
Officer Gerwig,
Yes, sir.
you said Mr. Printup told you that what did Mr. Printup tell you again?
On the scene or?
When you came on the scene to talk to him?
That his daughter, sorry, the names are real close together. His daughter Lucinda and her boyfriend Devin got into it. So
You said he told you they picked you up and slammed him too, right? Why didn't you put that in your report?
I believe
Would you like to refresh your memory?
I'm not in there.
You say
I said, if you're asking me about it, I take it's probably not in there.
it's not. So why didn't you put it in your report if that's what he told you? That seems like a pretty big detail.
He told this. Or he talked to my partner.
So basically, what he told you was they both were fighting, correct?
Right.
And he never told you who started it, correct? He never, he never said, was my client trying to protect himself or was he the aggressor, correct? You knew there was blood, but you didn't know where it came from.
Right.
He never said that the blood came from his daughter. But that was the assumption, correct? Now, when you came on the scene where Devin was, how many officers were there already?
The second.
Second.
Not the where his dad was, the one.
Right.
Second call.
Second call.
Everybody that was already showed up on the first one, so. Okay, 4 after me.
It was 4 after you
I believe so.
or 4 before you?
After, well, with me.
With you? Okay, so you were one of the first on the scene? And was Lucinda there when you came?
Which time? Initial.
To arrest Devin?
I believe that was her.
You believe that was her? So you wouldn't know who Lucinda was if you seen?
Not at the first time, no.
Got you.
So after the investigation,
And how many times have you met Lucinda and Lucius? Print up.
my partner has,
How many times have you met them?
have I met him once before?
You say once before?
Possibly, yes.
When's the last time you talked to Mr. Print up, Lucius Print up?
For this,
Before this court date?
I haven't.
You haven't? When was the last time you talked to him before you were on the scene with him? Before you pulled up on the scene to talk to Mr. Lucius to investigate the situation before you went to go arrest Devin? When was the last time that you talked to Mr. Printup? You said once before that, correct?
Correct.
When?
Said I did.
I said when? When was the last time? When was? You don't understand the time? You don't understand the time frame? I'm asking you, you said, this is what I'm trying to get to. How long have you known Mr. Printup? Because you said you remember his voice. You said you would know his voice.
From the phone call and speaking.
From the phone call and speakers. How would you know his voice from the phone call and speakers from something that happened a month ago? How many other people have you arrested?
That's how I know the voice, which I just told you from the scene, I know his voice from phone calls.
So you got that good of a memory?
I want to talk to him and see if hear a phone call, then it would be correct, yes.
Gotcha. But you forgot to put the body slam in the report.
Is that a question or?
I'm sorry, Young. I'm sorry. That was commentary, Young.
Okay, I don't need it.
I know,
Okay,
and I
get to the next
apologize. I apologize. Now, when you came on the scene, were you all trying to arrest, were you all trying to arrest him? Was it a collaborative effort of all the officers there? Yep, to arrest my client.
Or just painting.
When you did arrest him, was there, right?
Well, kind of resisting us, that, yes, all of us did.
Did he assault any officers individually? Did he assault you individually? Did he resist you individually, or were all the officers being resisted? And
Resisted myself and my partner.
so he was resisting the collaborative effort that you all were using to try and arrest him. Would that be a correct, accurate statement? Did he ever assault you? I do understand, he did say a negative comment. He did say a negative comment to you.
About my age and descent, that's correct.
He did, and which is reprehensible, but did he ever threaten you because of your age and descent?
About my age and descent, no, he never thought.
Did he ever threaten to damage any property you had because of your age and descent? So it basically was a statement. Out of my client's anger and the excitement of the situation.
A very derogatory statement. Yes.
No, very derogatory. I'm not gonna take that fact from you, I'm sorry that happened.
I get what you're saying, yes, there was nothing relation between, he's saying he's damaging anything of mine because of my age and descent, no.
Got you. All right, no further questions, John.
All right, anything else?
I have one moment, Your Honor.
Right.
Just for the people, Your Honor.
All right, you may step down. Thank you. Oh, your next word.
Thank you, Your Honor. People call Deputy Samaha, Your Honor.
Please come forward and be sworn.
Raise your right hand. Down swear in front. State spell your first and last name correctly.
First name, Deputy Samaha, spelled Deena, last name spelled Samah.
Give me that again. I'm sorry.
My last name?
Yes, please.
sir. Samah.
That was easy. All right. All right, go ahead.
Thank you, Your Honor. Deputy Samaha, what do you do for a living?
I work in the Washington County Sheriff.
And how long have you been employed there?
Over 2 years.
Okay, I'd like to direct your attention to March 14th of 2025. On that date, were you working?
I was.
What shift?
The noon shift.
And were you in a marked patrol car that day?
I was.
Were you in uniform?
I was.
Okay. And during that shift, did you find yourself at 8695 Spinnaker Way?
I did.
And how did you come to be at that address?
The call came out and deputies Hill and Berwick were responding to that address. And I started making my way over there just to back them up.
Okay. And did you come into contact with anyone at that address?
Not at that address. Deputy Berwick at the time gave us the description of the two, male and female, and we went to BOL, which pretty much looked for them in the area.
Okay. And did you find anyone matching those descriptions?
I did.
Okay. And when you went to 8695 Spinnaker Way, was there anyone you came into contact with there? Okay. And when you say Lucinda, who's Lucinda?
So initially when I arrived there, she was, from my knowledge, the victim at the time. She was bleeding from her finger. I had no context whatsoever at that time. I just made my way back to the laundry room where she was, and she was like washing her hands.
Okay. And how did she appear to you?
She was definitely in distress, hysterical, kind of all over the place.
Okay. And what did you do after coming into contact with Lucinda?
I escorted her out of the building and towards my patrol vehicle.
Okay. And when you got to your patrol vehicle, how did she appear then?
She was bleeding from the finger, so we tried to clean her up. Essentially, she was able to carry her own body weight. Then she just kind of started going in and out of consciousness on me. At that time, I had her sit in the back of my patrol vehicle. I had my door open. She was not coherent, was not able to give me any statement. And she, again, just could not carry her own body weight. So at that time, my priority was to stabilize her head so she wouldn't hit it.
Okay. And what happened after that?
We requested HVA and they arrived and they took over.
Okay. Nothing further for this witness, Your Honor.
Cross-examination.
I'm sorry, so, how do I pronounce your name? So I'll get it. Samaha. Nice to meet you.
SAMA. Okay. I got that. Go ahead.
Yeah, oh, no, I was about to ask that question. I wasn't about to ask that question. Now, how many officers were there by the time you got to the scene?
When I arrived, there were 4, possibly 5, if I remember correctly.
Got you. And okay. Did you interact with both Mr. Gibson and Ms. Printup or just Ms. Printup?
Just Ms. Printup.
You never seen Mr. Gibson put his hands on Ms. Printup?
No, sir. So I arrived after the fact. I was not there, no.
And you say she was in a hysterical state? Did she ever tell you that my client put his hands on you?
She did not give me a statement, no, sir.
She didn't give you any statement? Did she tell you that he didn't do it? He didn't do anything?
So from what I can recall properly, she did not give me any statement at all. Again, she was kind of in that state of going in and out of consciousness. So I just stopped questioning. We didn't get any further, no statement, no questioning. It was just kind of making sure that she did not hit her head at that point.
Did you see any injuries on her head?
Not on her head, no.
The only injury you seen was on her finger.
She was.
So, is it safe to say you don't know why she was feeling the way she felt, or?
That is correct. I could not tell you why she felt the way that she felt.
All right, thank you. No further questions, John.
Can you redirect?
No, Your Honor.
All right. Thank you, Jim.
Thank you, Your Honor.
No further witnesses for the people, Your Honor.
Right.
Witnesses, John.
All right. Go ahead.
Next one.
Well, what do you want to do?
Well,
Well, what do you tell me? No, you don't tell me. Go ahead. Do the next case.
Do the next case?
Want to do the bind over on this one?
Please.
Go ahead.
Okay, Your Honor, at this time, the people would motion for bind over. The court heard testimony from Deputy Gerwig saying that Lucius reported an incident where the defendant slammed the victim onto the ground, making her hit her head and lose consciousness. The court further heard from Deputy Strong that after this event, she had a cut and also was unable to hold up her own body, hold up her head, was incoherent from this injury that she sustained from the defendant. The court further saw body cam footage as well as the in-car footage of the defendant resisting the arrest of the officers, refusing to put his hands behind his back, 10 seconds away, refusing to walk to the car, fighting with officers while he was being arrested. The court also saw in the car the defendant spit on the car multiple times, as well as kicking out the window and causing extensive damage, over $2,000 to that patrol car. So I believe we have met the burden of probable cause in this case to ask the court to bind over.
Response.
Respectfully, Your Honor, when it comes to the assault with intent to great bodily harm, domestic violence, my client, first of all, we don't have any witness to witness it. The only thing we have is tape and the officer statements, when in the officer statement and the 911 tape in which you could hear him clearly say they both are fighting. We don't know who was the aggressor in that situation. Unfortunately, I can't cross-examine anybody to find out what was going on. We do hear on the phone where he said, he picked her up, my client, picked this print up and slammed her, but we don't know what that means. I can't cross-examine him and say, how was that? Was she trying to hit him? Did he grab her? And that happened. Was it in self-defense? We don't have any of that in front of us, Your Honor. respectfully, when it comes to the resisting obstructing a police officer, I think we got one resisting obstructing for the most part. In Michigan case law, it has to be an individualized attack on each officer when they charge it in different counts. In this case, this was one situation which a group of officers were attempting to arrest my client. It's not like he kicked one officer, punched another officer. It was one big, and I wouldn't even say it was assault. It wouldn't even go to the assault part, more the resisting part. He was potentially resisting arrest. He was actually frightened, and I wouldn't even call it resisting arrest. He was just frightened. But if we're gonna call it that, he was frightening arrest from multiple officers at the same time. So I would just say that wouldn't be against four different officers. Is one.
You have that case law?
I do, Your Honor. I'm glad you asked.
All right.
Give me 1 second. I did a lot of research on this case.
Okay. Only does you good if you can find it.
Say
nothing. Man.
Oh no, it's I wouldn't lie. I wouldn't.
No, I know. I'm just asking. You need to show it to me.
I know that's right.
Not here.
We do got, is there internet I got on here?
Pardon?
I need my internet to work.
No. I don't know. Mine's working. So you can't. There's a public access. You should be able to access it.
How to put it on. Usually I got cellular data. But my internet's not my cellular data's not working. Thank you.
Oh, yes, this is only one. I can if I flip it. No.
You're not talking. The way you're talking.
Did you get your internet?
I did, yeah.
Okay, good.
I'm looking for it. I guarantee you I got case law.
Okay.
Somebody was.
No.
If you go to people in yours, 314 mishap,
314 mishap.
399, 2016.
And what's it say?
It says, the holding is multiple counts of resisting obstruction where appropriate, where the defendant committed distinct acts against multiple officers. Let me see, first two convictions where the conduct was one continuous act that affected multiple officers.
Sounds to me like you said it's appropriate then to charge.
It's not appropriate to charge, Your Honor, and the ethnic intimidation, you really can't do that because with ethnic intimidation, he didn't do it act because of Mr. Gerwig.
I think actually Deputy Gerwig, he stated accurately, it would not amount to ethnic intimidation.
Right. Now, it was a horrible thing.
Absolutely reprehensible and hurtful and beyond the pale in terms of what another human being should say, but it may not constitute a crime. You're right.
I agree. So I think we only got about one count of resisting obstruction. Resisting obstruction. At the most, no ethnic intimidation, and we don't have witnesses here in which I can cross-examine anything that was being said. The biggest thing we heard is that they both were fighting. That was consistent. That was consistent in the report from Deputy Gerwig. That was consistent in the statement from off of the 911 call. We did also hear that he picked her up and slammed her. Well, we don't know the reasoning behind that, and we don't know what that means. I'm not able to talk to Mr. Printup and say, did he pick her up because she was hitting on him like this and dropped her? I'm not able to do that, Your Honor. So respectfully, we're asking to not bind over all the charges, but I would understand if there is one resisting obstruction charge.
One,
One,
okay.
I understand in the malicious destruction.
At what point are we talking about the resisting obstructor? Are we talking about in the hallway where at least I saw 3 distinct incidents? Are we talking about going down the stairway, which once at the bottom I saw another incident? And or are we talking about at the car when when he refused to follow the officer's instructions?
I would call that.
Which resisting and obstructing would you say is the one?
I would say, oh, well, I can't say. I said if anything. That's why I put if anything. But I don't see 3 different distinct acts, Your Honor. I see it all as one continuous act of the police trying to arrest him and put him in the car. That's how I see it. Once they got the cuffs on him, they got him up. He walked down.
Okay, yeah. I see how you may be looking at it. I think you're wrong, but okay.
Right, that's how I'm looking at it. Respectfully, that's what we asked, you know.
All right. Anything, I don't need any additional argument, but is there an argument from the people? All right, the court, after all of the evidence in the case and seeing the exhibits and the videos, would find that the people have indeed sustained their burden as to the majority of these counts. As it regards count 1, the assault with the intent to commit great bodily harm less than murder, not only by the statements, but also when Deputy Smaha shows up afterwards, her interaction with Miss Printup buttresses that case of her getting dropped on her head, because first of all, she has a cut. There's the blood that's in the apartment, but then also, as described by Officer Maha, her inability to carry on a coherent conversation. And as the deputy indicated, she was looking to destabilize her head. It's obvious that something had occurred given the statements that were made. I think that people could show, and a reasonable fact finder could conclude that there was an assault with intent to do great bodily harm done on Miss Printup by this defendant. So therefore, the court will bind the defendant over on that charge. Count 2, the malicious destruction of fire and police property. I don't think should be any dispute. One can watch the video and see definitely that that's exactly what he did. He did almost $2,500, $2,600 worth of damage to that vehicle in his little fit of rage that he went into. With regard to the resisting and obstructing, as contained in counts 3, 4, 5, and 6, the court, while understanding what the defendant is saying, if it were this one event in there, it could be charged as only, or properly found to be only one. But when one looks at the video, one can either do this by officer or the separate events that this defendant engaged in as they are trying to take him into custody. As I indicate, you just need to look at the acts of the defendant and what the officers had to do, because there are some officers that aren't even engaged with the initially, but have to then engage, which he then resists, that are happening in that hallway area or that vestibule area. There is then additional resisting and obstructing as he's coming down the stairway, and other officers have to jump in to try to get him to do that, particularly when he gets outside. He is walking after they've had to carry him down. He then goes into another event where he stops moving, and they have to then move the officer. The officers have to move him. They then finally get him to the vehicle. Sitting there, they're trying to get him to just put himself into the vehicle as they have sat him in the doorway, and he is refusing to do that. And then the officers have to re-engage with this defendant to then put him in. So whether it be by officer or whether it be by event, as the court has laid out, I think the charges of resisting and obstructing, and quite frankly, I think that there could be more, but I will bind the defendant over on 4 counts of resisting and obstructing. With regard to, and I've already stated it, with regard to the ethnic intimidation, I think it's one of the most despicable things this defendant could have entered into. Obviously not your finest moment, but also uh, just say shameful as a human being. In particular, shameful is you can roll your eyes all you want, but I'm gonna tell you what, when you can sit there and say that kind of thing, you as a man of color growing up in this country, I don't even know how you get there. Don't know how you get there. But I don't think it fits the crime of ethnic intimidation and won't bind him over on that charge. The defendant is bound over on counts 1 through 6. You know what? You better check your client. Take him back. Bind him over. We'll call the next case up after you check him. Got to finish his arraignment once he's here on the information, but I can't do it at this moment.
Any way that I can take his file back there with him?
Pardon?
Any way that
I don't think they're gonna allow him back. I'll leave that to the sheriff's department to do, but if they say no, sir, I can't order them to let that happen. All right.
Want me to go on before I say something? Okay, yeah, I'll go on.
Am I on? No? Okay. 1 through 6. Counsel, you acknowledge receipt of the information client stands to each of those charges.
Yes, Your Honor.
Been in every way, form, or reading, standing mute. Court will enter a not guilty plea. Pretrial in that matter will be set for
July 17th at 1:30 before Judge Slay.
July 17, 2025, 1:30, Judge Slay. Bond on that matter will continue. My understanding is that he's waiving on the other matter.
Yes, Your Honor.
Mr. Gibson, you're waiving your right to a preliminary examination on the other case?
Correct.
And you understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Correct.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution?
Correct.
People also waive their right?
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on count 1 with 2 and 3 following. Counsel, you acknowledge receipt of the information waiver treating?
Yes, Your Honor.
Your client stands mute.
Yes, Your Honor.
Defendant every way, form, or reading, standing mute. Court will enter a not guilty plea to all 3 counts. Pretrial in that matter will be set for
May 29th at 1:30 before Judge Slay.
May 29, 2025, 1:30, Judge Slay. Bond in that case will continue. Thank you.
Thank you, Your Honor. May I approach to sign the information?
Yes. Got a side vote. What's my other waiver? So I can get that.
Great day.
All right. Bird, you take care. Bird, I didn't know you ever gonna find that case law for me. That's okay. That's okay. I am a patient judge.
I appreciate it too. I had so much to go through because we had another motion.
Yes, I got you. I got you.
So you're a patient judge.
Wow.
When did that? Alan, did some change?
What do you mean you don't know? Seriously, Alan?
Court does call the case of People versus Jantz.
Andrew Childers appearing on behalf of people.
And Alex Warren Green on behalf of Jantz. Mr. Jantz, can you state your name for the court?
James Jantz.
All right. He's waiving his right.
That's correct, Your Honor. He's executing the form right now. In exchange for his waiver, the people have agreed to reduce the OWI third to an OWI second in circuit court, and have extended a sentencing agreement to no prison.
That's correct.
Mr. Jantz, you're waiving your right to a preliminary examination.
Yeah.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes.
All right. People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendant is bound over to circuit court on counts 1, 2, and 3 with 4 and 5 following.
Your Honor, we acknowledge receipt of the information, waive its reading and stand mute.
Defendant ever waived formal reading, standing mute. Excuse me. Court will enter a not guilty plea as to all 5 counts. Pretrial in this matter will be set June 3rd, 2025, 1:30 before Judge comes.
3 weeks.
Bond will continue. Thank you. I don't know. I don't have a loose information for whatever reason.
I will have them.
There wasn't one in that one. I don't know what's happening because that's like the 5th file today where we didn't have them. All right,
Your Honor.
Thank you. That's fine. Brad, who's on the other side of the person? Childers?
Here.
Okay. Let's call the case of the people versus Chalice McClung.
Andrew Childers, appearing on behalf of the people.
We're ready to this matter. I'm Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of client, Mr. Chalice McClung.
All right.
Chalice McLaughlin.
All right, thank you. All right, date and time set for preliminary examination. Ready to proceed, you may call your first witness.
There they are. I'll start with, we'll have Deputy Phillips testify first.
Please come forward and be sworn.
Please raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth. The state spell your first and last name for the record. Alex, A-L-E-S, Phillips, P-H-I-L-L-I-P-S.
All right, main court.
Sir, how are you currently employed?
I am currently employed with the Washington County Sheriff's Office,
And how long have you worked there?
approximately 5 years.
Were you working in that capacity back on April the 15th of this year, 2025?
I was,
Were you alone or with a partner at the time?
I had a partner,
Who was that?
Deputy Bovee.
Directing your attention to, I believe it was kind of mid-morning on that date, April 15th. Were you dispatched in relation to a possible stolen vehicle?
I was,
Okay, tell me about that.
gave me a call, for a reported unit at the hotel located at 1275 South Huron. Myself and my partner initially called and spoke to the complainant, who preliminary statement, and then advised videos, cameras at the hotel.
Okay, and this, what kind of hotel is this on here?
This is the Marriott.
Okay. Did you and your partner physically respond to that location, or did you just communicate via phone?
We did respond out.
Okay. Did you or your partner make contact with the owner of that vehicle?
We did.
Okay, tell me about that.
She advised that she left her car there.
Two things, Your Honor. One, I'm not offering this for the truth of the matter asserted, but only to explain, in part, to explain what the deputies did. But further, and I'll get to this, permission to use property hearsay is admissible under 1101B8 at preliminary examination, and I do intend to elicit that testimony.
All right, very good. Then I'll overrule the objection with the understanding that it's not offered for the truth of the matter, except to the extent it goes to the issue of permission.
Correct. Thank you. Go ahead, Deputy Phillips.
She advised that she left her car in the parking lot overnight, and when she returned home, the vehicle was not there.
Okay. Did she let you know if anyone had permission to take that vehicle at that time?
No, to the relevance of this, I don't, it's my understanding we're not doing the UDA, but just the.
Oh, I didn't know that.
Oh. Okay.
What?
I was planning on making sure I can prove all my elements.
Oh, no. Oh, yeah, come on. I guess.
¿Cuánto tiempo? 15th, Your Honor.
July 15th.
El 15 de julio a la 1:30.
Anyone else for the, Mr. Ricardo? Is that all you had on your list, sir?
It is, Your Honor.
All right, have a good afternoon.
You too, Your Honor. Thank you.
Ms. McLaren?
Judge, I've got Jonathan Griggs, case numbers 23-4473 and 24-3565. Judge, I've just entered on the case. We've got an evidence review scheduled on May 22nd, and I'll know where we're at after that.
Okay, when is it?
May 22nd.
May 22nd. Oh, you want to set it for, July 15th?
Yes, sir, that'd be fine.
July 15th at 9 o'clock. Any objection?
Thank you, Judge. That's all I've got. You too.
Mr. Martinez?
Good afternoon, Your Honor. Thank you for taking me.
Good
I
afternoon.
have page, I don't know what page, it's Billy Tipton, first time up. He's
25 CF 491.
That's correct. And Mr. Tipton is on Zoom as well, Your Honor. He is muted, but you can see his name.
All right.
I've received discovery from the government on the matter. We need to set the depositions, and I need to have the opportunity to discuss this matter with the state to see if there's a resolution to the matter.
July.
Record should reflect we had a bench conference in this case, and while the testimony of Deputy Phillips has started, my understanding is that there was additional evidence that came that is now there, that as a result of a search of a phone that is now in the possession or will be in the possession of people that need to be turned over to the defense.
That's correct. And I apologize. I am last minute covering this. The assigned APA became ill and had to excuse herself. And I trust Mr. Brown that he had this conversation with Ms. Douglas earlier in the morning. So I have no problem with that. And I think that based on that new discovery and the fact that we would ultimately likely have to just recall the same witnesses, that moving this whole exam to a new date to allow an opportunity to receive and review that discovery maybe makes the most sense.
So what I will do is I'll move to my next available date, which is June 3rd, 2025, 9 a.m. That's before me. All right.
Thank you.
Yeah. All right. Thank you. His bond will continue.
Thank you, Your Honor.
Adjourn.